Come, shall we start?
Right. So we are starting, we are going live. Hello, everyone. Welcome to the 5th Professor Shamnad Bashir Memorial Lecture organized by LiveLaw. I am Manu Sebastian, Managing Editor of LiveLaw. Professor Shamnad Bashir, who left us prematurely in 2019, was a brilliant academic who was gifted with revolutionary ideas. Driven by a commitment to make a positive social change, his activities were not just confined to the walls of the classroom. He had an activist zeal, which led him to use law as a tool for making a positive social change. His intervention in the famous Novartis case, as well as IDIA, his brainchild, which is still continuing, are the examples of his commitment to social justice and to see a better society. His untimely demise in 2019 was a great personal as well as a professional loss for Team LiveLaw, as he was our dear mentor as well as a member of our advisory council. It is to honor the legacy of Professor Shamnad Bashir that LiveLaw is organizing this memorial lecture every year. By keeping his memories alive, we hope that his life and vision would inspire the next generation of students. We have had the privilege of having esteemed speakers to deliver the memorial lecture every year. This year, we are honored to have Justice Gautam Patel, former judge of Bombay High Court, to deliver the lecture on the topic Artificial Intelligence, Trademark, and Copyright Emerging Issues. I am sure this topic would have been close to the heart of Professor Bashir as well. Justice Gautam Patel is an erudite judge who has delivered landmark judgments in various fields of law. He has always strived to uphold the liberties of citizens. The best example is his recent judgment, which struck down the IT rules, which enabled the government to notify a fact-check unit for social media intermediaries. Justice Patel held that the rule would kill dissent in social media and would enable the government to become the sole arbiter of truth. Justice Patel is also hugely popular for the use of humor and wit in court proceedings. He has lit up various mundane proceedings through wit and wordplay, and many of his orders have become hugely viral in social media, and that is why he is very popular among the younger crowd as well. So we are very honored and privileged to have Justice Patel to deliver the Shamnad Bashir lecture. I welcome Justice Patel on behalf of Team LiveLaw. Over to you, sir.
Thank you, Manu. Good evening to everyone. My thanks to LiveLaw for this opportunity to present a few thoughts. The previous speakers in this series are a formidable galaxy. Chief Justice Muralidhar, Justice Ravindra Bhatt, Chief Justice Chandrachud, and Professor Mohan Gopal. The subjects of their lectures range from legal education to fundamental rights, disability rights, and the judiciary. Every single one of these lectures is worth one's time. I can only hope that my address today reaches those high standards. I got to know Shamnad during my tenure as a judge of the Bombay High Court, specifically while I was assigned intellectual property cases. We engaged in lively discussions. I followed several discussions and articles on Spicy IP, his blog, a name I adored for its sly sense of humor, typical of the man. And there were times when, possibly against my better judgment, I responded on a question of law, although unrelated to any of my own decisions. I also recollect having written a guest article or post for the online journal as well, which thrilled him because at that time, there were not many sitting judges willing to engage publicly. Shamnad was a formidable advocate in his own right with a dazzling educational career. NLS, Oxford, and more. He soon gained international renown. His passing in August 2019 robbed us of a person I sincerely believe could be called a true Ratna or jewel in our IP firmament. his acuity, insight, openness to debate and discussion, his unwavering commitment to the concept of rights, all these made him utterly unique. They say that those whom the gods love die young, and Shamnad must have been truly beloved of the gods. If there is one word I would use to describe Shamnad, it is transformative. It is apt for him personally too. Just look at the images available online that show his journey from an early long-haired and bearded iconoclast to the sleek looks of later years. But of him, I think it can truly be said that he transformed anything he touched: people, institutions, learning, the body of law. I must mention that incredible initiative IDIA, Increasing Diversity by Increasing Access, an all-inclusive program aimed to create diversity and to build bridges across seemingly impossible socio-economic divides for young people entering law. He could spot talent like no one else. When he passed, my dear friend and sometime colleague on the Bombay High Court bench, Justice Somasekhar Sundaresan, himself a jurist with a mind as sharp as a razor, wrote a fine obituary for him in the Mumbai Mirror on 10th August 2019. I want to begin by quoting Som briefly. He writes, "There are occasions in life when one meets people so extraordinarily full of energy and zest for life that you think about whether they are living in multiple incarnations of a human being in one lifetime. You wonder whether their far more than normal speed of getting things done would lead them to have a proportionately shorter time on the earth, since they achieve in a short span what others take decades to do." Shamnad Bashir was one such person. Shamnad had dedicated his life to applying his knowledge of the law for the betterment of humanity. An expert in intellectual property law, Shamnad toiled hard for applying the rule of law governing intellectual property to enable fair access of the common man to medicine and pharmaceuticals. He would work around the clock, supporting the legal teams he would be part of in intense litigation involving interpretation of intellectual property rights. It is appropriate then to dedicate my address this evening to the memory of my friend, Professor Shamnad Bashir. And it is equally imperative that I take up an issue that would undoubtedly have engaged him greatly. Some may be aware of the extremely interesting lawsuit filed in the Delhi High Court recently by a news channel, ANI, against OpenAI, the entity that developed and runs the famous chatbot ChatGPT. The issues in the case are of critical importance to IP law. But this is only the first case in India of its kind. OpenAI is facing similar claims in other jurisdictions. The dispute revolves around the way AI works. At its heart, AI is about pattern recognition, detecting trends, self-learning from data sets, and then making predictions. The technology is adaptive. The more data you feed it, the more accurate the analysis and consequently the prediction set. Very complex tasks are handled with reasonable accuracy in far less time than a human ever could. The system processes data, tests it, assesses its performance, and gets better. As a parallel, imagine an associate or an intern in a law firm with a head stuffed full with every single law and judgment, fully analyzed, annotated, marked up. Even with so prodigious a faculty, a normal human brain can only process so much and at a fraction of the speed of a machine. That's the seductive power of AI. But underlying all this speed and accuracy is a fundamental problem. AI is data greedy. It needs data, vast amounts of it. And on the internet, it grabs, scrapes, and appropriates anything and everything it can. It needs what are called LLMs, large language models. That is the beginning of the problem identified by ANI in its lawsuit against OpenAI. ANI says, as do others, that its data is protected by copyright. It offered licensing to OpenAI, which refused. Nonetheless, OpenAI seems to be using ANI proprietary and protected material. The case itself is posted to January 2025, and the Delhi High Court has appointed amicus to assist on the technical aspects. The question is this: is open source exempt from the normal considerations of copyright law? For AI, does the fair use or fair dealing standard mean something different? To more fully appreciate the context and contours of AI and IP law, we should understand what pattern recognition, the heart of AI, means. Gautam Bush, the co-founder of Visio AI, a software platform for computer vision and deep learning, explains. At the age of 5, most children can recognize digits and letters, small characters, large characters, handwritten, machine printed, or rotated, all easily recognized by the young. In most instances, the best pattern recognizers are human. Yet we do not understand how humans recognize patterns. The rapidly growing amount of training data generated is making it impossible for humans to interpret and driving the need for machines to be able to identify patterns quickly and accurately. The ability to automate the recognition of patterns and regularities in data has many applications, from facial recognition software to tumor detection. Pattern recognition analysis analyzes incoming data and tries to identify patterns. The identification of regularities in data can then be used to make predictions, categorize information, and improve decision-making processes. While explorative pattern recognition aims to identify data patterns in general, descriptive pattern recognition starts by categorizing the detected patterns. Hence, pattern recognition deals with both of these scenarios, and different pattern recognition methods are applied depending on the use case and form of data. Consequently, pattern recognition is not one technique, but rather a broad collection of often loosely related knowledge and techniques. Pattern recognition capability is often a prerequisite for intelligent systems. At the heart of a pattern recognition system are computer algorithms that are designed to analyze and interpret data. The data inputs can be words or text, images, or audio files. Hence, pattern recognition is broader compared to computer vision, which focuses on image recognition. In 1985, Satoshi Watanabe defined a pattern as the opposite of chaos. It is an entity, vaguely defined, that could be given a name. In other words, a pattern can be any entity of interest that one needs to recognize and identify. It is important enough that one would like to know its name or identity. Therefore, patterns include repeated trends in various forms of data. For example, a pattern could be a fingerprint image, a handwritten cursive word, a human face, or a speech signal. A pattern can either be observed physically, for example, in images and videos, or it can be observed mathematically by applying statistical algorithms. Pattern recognition is constantly evolving, driven by emerging applications that are not only challenging, but are also more computationally intensive. The goal of pattern recognition is based on the idea that the decision-making process of a human being is somehow related to the recognition of patterns. For example, the next move in a chess game is based on the board's current pattern, and the buying or selling of stocks is decided by a complex pattern of financial information. Therefore, the goal of pattern recognition is to clarify these complicated mechanisms of decision-making processes and to automate these functions using computers. Pattern recognition is defined as the study of how machines can observe the environment, learn to distinguish various patterns of interest from their background, and make logical decisions about the categories of those decisions. During recognition, the given objects are assigned to a specific category. In general, pattern recognition can be described as an information reduction, information mapping, or information labeling process. In computer science, pattern recognition refers to the process of matching information already stored in a database with incoming data based on their attributes. Artificial intelligence, or AI, refers to the simulation of human intelligence, where machines are programmed to think like humans and mimic their actions. Most prominently, fields of artificial intelligence aim to enable machines to solve complex human recognition tasks, such as deep neural network face recognition. Pattern recognition is a branch of AI. Most modern use cases of pattern recognition are based on AI technology. Popular applications include speech recognition, text pattern recognition, facial recognition, movement recognition, recognition for video deep learning analysis, and medical image recognition in healthcare. Now let's look at some of the key issues that affect trademark and copyright law in the interface with AI. The most obvious problem with trademark law is that of the potential to render trademarks generic. This can be fatally damaging. Because AI analyzes vast data sets of language and usage to identify trends and patterns, trademarks are in constant risk of becoming generic more quickly, reducing their protectable status. Allied to this is the concept of distinctiveness in trademarks. As we know, a trademark's distinctiveness is crucial to its protection. AI can easily generate new and seemingly unique materials capable of trademark protection, names, logos, combinations. The challenge for us lies in deciding whether an AI-generated mark is sufficiently distinctive to merit trademark protection. That takes us directly to the question of infringement, and with it, the problem of deep fakes. AI tools and algorithms can be used to create deep fakes or other forms of counterfeit goods labeling that infringe existing trademarks. This raises the twin specters that are central to trademark law: increased confusion, consumers being cast into a state of wonderment, and damage to the reputation of the brand. INTA, the International Trademark Association, noted this 3 years ago in June 2021 in a feature published called Deep Fakes versus the Truth, Putting Brands at Risk. It opens with the catchy expression, "Seeing is no longer believing." The authors say that the proliferation of deepfakes puts at risk not only brand owners, but the public as well. It is, they assert, the next big global cyber threat. Specifically, that in future, deepfakes will be undetectable to the ordinary consumer, she of average intelligence and imperfect recollection. The issue is indeed grave, especially when one considers the result of what are called generative adversarial neural networks. What happens here is that one machine creates a fake. It passes it on to the next machine, which detects the flaw in the fake and reports back, thus the adversarial process. The first machine then goes to work to correct the flaws using its generative power and bounces it back to the test machine. This adversarial process, not very different from what one sees in law courts, continues in this manner until the final result is a nearly perfect rendition, but nonetheless a fake, be it a photograph, video, music, or anything that can be perceived by the human senses. Self-evidently then, if you own a brand and are confronted with a deep fake, your brand is in peril. The damage to the brand's reputation is incalculable. What is possibly worse is that if the deepfakes simply gain currency and circulation on the net, the dilution continues, but without necessarily being able to identify the rival claimant or user. The issue of trademark counterfeiting is by no means new, nor limited to, nor introduced by AI. It has existed for ages. My own experience as a judge assigned IP cases shows this. There were several major corporates with a slew of brands, HUL and Asian Paints prominently, which faced constant trouble with counterfeiting of their trademarks, labels, brands, and logos. In one case, I was told that there exists a remote village, the only industry of which is to produce indistinguishable counterfeits. For personal care products for skin, eyes, hair, the damage caused is not just to the brand, though that is significant. There is a public interest element too, and the question of safety. The legitimate owner is regulated and subject to quality control and quality checks. The spurious product, at a fraction of the price of the original, puts at risk the health of the unwary consumer. It is no different for paint or cement. Warehouses stuffed with sacks of counterfeit cement or buckets of paint pose a very real risk to unsuspecting consumers. This problem is exacerbated when deep fakes driven by AI are so good that it is impossible for the brand owner, let alone the hapless, unfortunate judge, to tell one from the other. In a real-world scenario, consider what you would have to bring to court to substantiate a case against an indistinguishable AI-generated deepfake. The very prospect should give the IP bar sleepless nights. Is there an advantage for brand owners that is built into AI? What about trademark monitoring and enforcement? If it is, after all, about pattern recognition, can we not use AI to monitor at least online or digital markets and exchanges, social media platforms and the like, to track trademark infringement? I believe we could, and at least the large or high-value brand owners need to reposition their in-house capabilities to harness the pattern recognition strengths of AI, not to create fakes, but to do two things instead. First, to detect, track, and monitor deep fakes that affect them. And second, to constantly generate proprietary variants on the brand name and logo. This is a bit of a cat and mouse game that never ends and demands the development of sophisticated skills and technologies by brand owners. But is that not a small price to pay? After all, some of the big players are using technology itself to combat deepfakes. There is the use of digital watermarking and fingerprinting, buried and invisible signatures, and the introduction of digital artifacts into images, names, depictions, and videos to mask or distort at the minute pixel level. Recently, I experienced this firsthand. On a holiday overseas, flicking through some movie channels late one night, I noticed that the movie had a warning sign at the beginning that said that this copy was digitally watermarked. I couldn't see the watermark. It didn't matter. That digital watermark identified the hotel, the time, and the room number. Obviously, that information was being relayed in real time to some repository held by the rights owner, making it possible to almost instantly detect any fraudulent activity. However, there is a risk that AI-powered tools could make mistakes, leading to false positives and negative consequences for business. Note too that AI systems are not totally ever agnostic or neutral. They have their own biases, and some of these are injected by or emanate from human biases while designing algorithms. This is particularly true when there are issues of segregation, data set classification, and discrimination. Human biases are often baked in to the AI model. There, they are deployed on a much larger scale, amplifying the bias. If not addressed, bias affects the targeted individual, for our purposes, the consumer. In designing ad campaigns tied to brands, for instance, baked-in biases can generate dangerous results. This is also true of image generation, healthcare, and predictive policing tools. Malcolm Gladwell's very recent TED Talk about bias in policing is extremely interesting in this regard. Let me turn to copyright. First, some of the issues we encounter and will continue to encounter in the time ahead. AI is especially good at generating creative works like music, art, and literature. Who owns the copyright in these generated works? Is it the AI developer, the user who prompts the AI, or the AI itself? I will return to this in a few moments. Typically, AI-generated works may lack the human element that is traditionally required for copyright protection, the sweat of the brow principle. This raises an imponderable tied closely to the first. Are AI-generated works sufficiently original and creative enough to merit copyright protection? I mentioned fair use earlier. AI can be used to create derivative works based on copyrighted material. Fair use, copyright infringement. What are our tests to determine either? AI can be a powerful tool to identify copyright infringement online and plagiarism. Again, we have the problem of bias, false positive, and negative consequences for copyright owners. Some 7 years ago, WIPO magazine carried an article by Andres Guadamos, a senior lecturer in IP law at the University of Sussex. Let me quote the beginning for its startling imagery. Google has just started funding an artificial intelligence program, he writes, that will write local news articles. In 2016, a group of museums and researchers in the Netherlands unveiled a portrait entitled The Next Rembrandt, a new artwork generated by a computer that had analyzed thousands of works by the 17th century Dutch artist Rembrandt. A short novel written by a Japanese computer program in 2016 reached the second round of a national literary prize. And the Google-owned artificial intelligence company DeepMind has created software that can generate music by listening to recordings. Other projects have seen computers write poems, edit photographs, and even compose an entire musical. The point is that AI is no longer just a tool, like, say, a paintbrush and an easel or paper and pencil, things used in the creative process to generate original works by sweat of the brow that qualify for copyright protection. The newest iterations of AI, the algorithm, is no mere tool. It is the creator, and it is bringing into existence a work of and on its own. It is actually making decisions. Let me take a few examples from literature. I am not taking instances from the visual arts or cinema because that would be very cumbersome online. Let's just consider some of the most famous opening lines in literature. This is Franz Kafka's Metamorphosis. As Gregor Samsa awoke one morning from uneasy dreams, he found himself transformed in his bed into a gigantic insect. Jane Austen, in Pride and Prejudice. It is a truth universally acknowledged that a single man in possession of a good fortune must be in want of a wife. George Orwell, 1984. It was a bright, cold day in April, and the clocks were striking 13. Tolstoy, Anna Karenina. Happy families are all alike. Every unhappy family is unhappy in its own way. And one of the best, Herman Melville in Moby Dick, Call Me Ishmael. There are others, and I resist the temptation to go all Nabokov on you this evening. So I did this in preparation for this lecture. I went off to ChatGPT and asked it to give me opening lines of a literary work similar to Anna Karenina by Leo Tolstoy. It returned this. All happy families are content in their own way, but the disquiet of a heart in turmoil finds 1,000 paths to misery. Derivative. Influence. Another example. In every marriage, there exists a quiet understanding, a sort of truce between expectation and disappointment. And yet, it is the most fragile of understandings that can unravel the fabric of a life. The last, I loved. It is a truth universally acknowledged, if not often spoken, that the smallest inflection of a woman's smile can alter the fate of a man's heart. And then ChatGPT happily told me that these lines attempt to capture the philosophical undertones, moral examinations, and richly atmospheric qualities found in Anna Karenina. And then, as if there's a person behind it, it said, if I'd like a different thematic exploration, I should let it know. I did. The last of these, which I just read, was clearly a meld of Austen and Tolstoy, so I went on to Moby Dick. ChatGPT told me this. Here are some opening lines in a style reminiscent of Moby Dick, dense, philosophical, and imbued with the same reflected, layered storytelling and maritime imagery. Just consider the first. Call me Ashwood. Though names are but shifting tides on the vast ocean of memory, I find the sound of it steadies me in the dark. Then I was told, 4 examples later, that these lines aim to capture the introspective, symbolic tone of Moby Dick, philosophical inquiries, maritime references, and symbolic undertones, all with a touch of existential pondering. Let me know if you'd like adjustments or explorations of other thematic elements, ChatGPT said. Too specific? I tried these keywords in ChatGPT: seafaring, novel, literature, whale hunting, giant whale, leviathan, storm, self-realization. And it returned different results. At once we see the multi-layered problem. The generated result is indeed unique. It's not strictly plagiarism, but it is admittedly and demonstrably derivative. It explores the same themes in a different way, but it has detected a pattern to those themes. What did I do? I wrote none of it. What I did was to create on my own, arguably entirely originally, the keywords or phrases that generated this result. Now the problem. Is there copyright in my unique arrangement of the keywords and phrases? A different set or a different arrangement may give a different result. I tried this by keeping only giant whale and novel, 2 keywords. ChatGPT gave me something totally different. Let me read this one. It was said that the great Leviathan could hear the creak of a ship's timbers from 1,000 fathoms below, that its breath could stir the sea into fury or calm with a single exhale. They called it Thalassaur, the name whispered in taverns and on decks, as though speaking it aloud might summon its vast, unseen presence. That's pretty powerful writing, but it's AI generated. What I have said about literature is equally true of AI image generation. Using any of the popular AI image generation tools online, from Adobe Firefly to Dolly, Midjourney, Stable Diffusion, or Getty's generative AI, one can create seemingly original works based on a unique arrangement of keywords and phrases. Where lies the copyright? This is a twilight zone in copyright law. How on earth would you begin to bring an infringement or passing of action, or both, in a situation like this? Consider the startling example of a university failing a student because his answer sheet was entirely AI generated. That came recently before the Punjab and Haryana High Court. The case was ultimately closed because the university accepted the student's answer. Was that permissible? Was it right? Was it wrong? The student's argument was that even if it was AI generated, it was he who used a tool to generate it, namely AI as a tool. And since it was he who had done it, he had rights over the result, and the answer was his. Let me quote from an exceptionally fine research paper by Madhu Rewari and Sri Mishra of Anand and Adan, published in Asia IP Law. Using generative AI for content creation challenges the application of fair use, fair dealing doctrines. In such cases, one may consider whether the AI-generated work is a derivative work meant for commercial exploitation or for educational research, teaching, or other purposes. One may also look at the transformative nature of AI-generated output to see if it transforms the original work or merely supersedes it. That said, AI-generated works usually involve complex steps before returning an output based on the user's text prompts. This may involve various tools to understand the relationship between the prompts and the associated copyrighted images collected by the AI system, creating clusters of similar text-image pairs and the representations of images with similar text-image combination, which may not necessarily be copied images. Such steps can be key to determining if the AI-generated output is inherently transformative to be accepted under fair use. Is an AI-generated work using copyrighted works protected as fair dealing or fair use? We are on shifting sands here. There is a 2022 class action lawsuit, Anderson versus Stability AI, in California, alleging that several AI image generative platforms unauthorizedly use their copyright-protected works as dataset training models, allowing users to generate unauthorized derivative works, very similar to the contentions in the ANI case. The intriguing question is whether the plaintiffs are correct in saying that all AI-generated works that use copyright-protected data are impermissible derivative works, irrespective of the complexity of the technology or the input needed to produce the result. Stability AI has also later been sued by Getty Images. That case is that Stability unauthorizedly copied 12 million Getty collection images, removed or altered copyright management information, added false copyright information, and so on. Authors Guild versus Google is a case where Google used digital versions of print books to create Google Books. A first settlement failed. A second went through, but has been widely disparaged by leading writers across the world, saying it impermissibly impacts their rights. How much of the original is too much for AI purposes? Remember that in AI image creation, we have a sort of double whammy. Uniquely composed text is used to trigger an AI-generated image. And what I have said about literature and art also applies to music. A few days ago, ABBA's Bjorn Ulvaeus warned that generative AI will potentially cause great harm to musicians when it uses their work without any form of licensing. And there is, of course, the fact that the tech companies that facilitate AI generation profit hugely from this kind of use. New legislation and building public awareness about detecting and recognizing deep fakes are going to be the challenges that lie ahead. In a 2021 research paper, Sakshi Mittal, a student at the University of Petroleum and Energy Studies here in India, writes about a primary concern, that of ownership. Who owns the copyright? As she says, if an AI system creates a painting or a song, who owns the copyright to that work? Is it the AI system itself, the programmer who created the system, or the person who trained the system? There is also the question of authorship and the allied concept of originality, which I have illustrated. And there are, of course, the trademark issues that I mentioned earlier. Our current legislation has no mechanisms I know of to readily deal with these emerging issues. Our laws are hopelessly out of step with the technology and are always behind it. What are we to make of this? Should we just abandon hope, all those who would create something original? Or frame new legislations designed to address specifically AI-generated works? Will digital fingerprinting, watermarking, and blockchain technology assist? I see before me a young person highly skilled in design, tasked with designing new logos, labels, and artwork. Is her or his job now redundant? Is she or he replaceable by someone who knows her way around keywords and the technology, but has no clue about design, color, aesthetics? What happens to this difficult concept called originality? In August 2024, Yvonne Nyabuk of the Australian Catholic University noted, traditional IP laws are increasingly inadequate to address the complexities introduced by AI-generated content, necessitating a rethinking of existing frameworks. The study emphasized the need for recognizing AI's role in the creation of new works and invention, and the importance of developing balanced approaches to protect both human and AI contributions. Ethical considerations such as accountability, transparency, and fairness were also deemed crucial in ensuring responsible AI use. Overall, the study called for a comprehensive and proactive approach to integrate AI into IPR, ensuring robust protections while fostering innovation. Since Manu mentioned my habit for being naughty, I am now going to ask him to allow me to share a screen. And I want to show you 3 images that I just generated using Adobe Firefly. My prompt was Indian lady advocate, Supreme Court of India, arguing. I could generate a set of photographs or artwork. Strangely, and this is important for us, the system allowed me to upload an image, possibly someone else's image, for reference purposes. Have a look at the 3 images. Let me share the first one with you. Manu, could you just turn on sharing, please?
Yes.
Not possible?
Just a second, sir. I'll just.
Yeah. All right, have a look at this. This is my keywords here for Indian Lady Advocate, Supreme Court of India arguing. And it gave me these fairly bizarre results. And then in composition said I could upload an image for comparison or reference purposes. The next set of images, the next image is equally strange. I'll just get to it in a minute. Have a look at this one. I have no idea where it picked up these ridiculous monuments. You do see some blindfolded lady of justice. Why these people are wearing these strange robes outdoors in the countryside completely escapes me. But there you have it. The third is possibly the most wonderful of all. Let me show that to you. And this was the artwork that it generated. Equally strange. But the question is this all unique? And is this copyrightable? I am left to myself tempted to go out and claim copyright in everything. Wouldn't you? And I leave you now with this last thought, which is to figure out whether my entire address this evening is at all original or wholly AI generated. Thank you for listening.
Thank you, Justice Patel, for that interesting and enriching lecture on AI. It was a very eye-opening session about the various consequences which AI can create for our life, as well as for the law, and various ethical considerations, as well as the social conundrums which arise due to the use of AI, such as the impact on copyright, the impact on the very concept of originality, human creativity, as well as trademark and other fields of law. Thank you, Justice Patel, and also for that AI created images which made.
Thank you so much.
Thank you, sir.
Thank you.